Presidential spokesperson Salvador Panelo will not be surprised if President Duterte is infuriated following the news that former Calauan Mayor Antonio Sanchez may be released from jail. Panelo assures the public that the president will not let it happen.
Magagalit siya because if the law says he's disqualified, bakit mo i-consider?
Republic Act 10592 states that an inmate cannot be granted an early release through Good Conduct Time Allowance if he committed a heinous crime. Sanchez was meted with 7 sentences of reclusion perpetua for the rape and murder of UP Los Baños students Eileen Sarmenta and Alan Gomez in 1993. He is also serving 2 sentences of reclusion perpetua for the double murder of his political opponent Nelson Peñalosa and son Rickson.
Mr. Sanchez under Republic Act 10592 is not eligible. So the President, as the chief enforcer of the law, will have to follow the law.
For Panelo, who is also Sanchez's former lawyer, there is no need to reevaluate Sanchez's case because it is clear that he is disqualified for early release. But Malacañang welcomes some lawmakers' suggestion to conduct hearings on the GCTA. Justice Secretary Minardo Guevara, for his part, says people who have issues in the current law must ask Congress to amend it.
Ang takbuhan nyo, Kongreso. Kasi Kongreso ang nagpasa ng batas na yan. Pulisiya yan para mabigyan ng second chance yung mga nag-reform na ng mga sarili nila.
For News 5, Maricel Halili, we are One News.
The Supreme Court felt it had to clear things up after the furor over the supposed impending release of former Mayor Antonio Sanchez. On Friday morning, it explained the nuances of RA 10592, which amends the provisions of the Penal Code for good conduct credits. At the onset, the High Court spokesman says it has nothing to do with the Sanchez.
The Supreme Court did not order the release of Mayor Sanchez in its recent decision in the consolidated cases entitled Inmates of New Bilibid Prison et al. Versus De Lima et al.
Hosaka said the Supreme Court only followed a fundamental doctrine in criminal law in the ruling.
Penal laws which are favorable and advantageous to the accused are applied retroactively. Thus, the Supreme Court struck down the provision in the IRR and ruled that RA 10592 was to be applied retroactively as it had the effect of lowering or reducing the sentences of prisoners, hence favorable to them.
Hosaka said the expanded Good Conduct Time Allowance was not authored by the High Court, but it was passed by Congress in 2013. He also pointed out that they do not implement the law.
The implementation of RA 10592 is also not within the jurisdiction of the Supreme Court, but rather, like all laws, the implementation and execution of RA 10592 is left for the executive branch of government.
The families of UPLB students Eileen Sarmenta and Alan Gomez says that they are seeking possible legal remedies to stop the possible release of Sanchez. Senate President Tito Soto and Senate Minority Leader Franklin Drilon suggest of filing a temporary restraining order to stop the implementation of RA 10592. But the Integrated Bar of the Philippines President Dumingi Cayosa doubts it will work.
Medyo mahirap na i-TRO ng basta-basta ang isang kasalukuyang batas. Sa aming patingin, tama naman yung batas duman sa proseso, maganda naman yung layunin.
Criminal lawyer Harry Roque said the victim's family should go to the Board of Pardons and Parole.
Mali kasi ang procedure kung hindi pakikinggan yung pamilya mismo. So sa akin, pwedeng tutulan pa rin yan dahil yung kasama dun sa tinatawag nating reparations, dapat pakinggan naman kung ano yung damdamin ng mga naging biktima.
But according to the Board of Pardons and Parole, they do not have jurisdiction over RA 10592 and that the Bureau of Corrections and the Bureau of Jail Management and Penology are the ones tasked to compute the good conduct time allowances of inmates.
Kailangan meron din naman nag-check. May psychologist dyan, may social worker, may probation officer.
They also want the list of the eligible inmates to be made public. For News 5, Romel Lopez, we are One News.
There still are questions as to whether or not Antonio Sanchez qualifies for early release for good behavior in prison. The former mayor still has 14 years left in his 40-year jail sentence. He got 9 counts of reclusion perpetua for a 1993 rape-slay case. Should that keep Sanchez from going free? The Justice Department initially did not seem to have a definite answer. On Tuesday, Secretary Minardo Guevara said it shouldn't and that Sanchez will join thousands of other inmates whose cases should be reviewed for good conduct time allowance. On Friday, however, the DOJ said Sanchez may be excluded after all. This follows the statement from Malacañang, which said the letter of the law is clear. The GCTA does not benefit recidivists, habitual delinquents, escapees, and people charged for heinous crimes. Those include murder, rape, and kidnap for ransom. So does that mean Sanchez is disqualified for early release? Malacañang thinks it should, calling it the inevitable conclusion. But the provision on excluded prisoners is written for inmates whose cases are still pending. Sanchez's case was settled in 1995. Does it still apply? Who will make the decisive interpretation? Justice Undersecretary Mark Perete says the law on it remains unclear, but in case Sanchez does proceed to undergo review for GCTA, the final say goes to the National Central Management Screening and Evaluation Council. That body is comprised of jail officials, psychologists, and social workers. They will decide if Sanchez's conduct records are good enough. And they have to be. If Sanchez wants to reduce his sentence, since the Board of Pardons and Parole, the other body in charge of releasing prisoners early, already told him no when he asked for executive clemency last December. Will Sanchez's conduct record stand scrutiny? Senator Franklin Drilon, who prosecuted Sanchez when he was Justice Secretary in 1995, does not think so. He pointed out at least one clear conduct violation just from Sanchez's latest appearance from Bilibid. Polo shirts, slacks, leather shoes, and a watch are not part of the standard prisoner's uniform, and there are 48 other violations authorities may dig up to argue for preventing Sanchez from leaving prison. And still, on the good conduct time allowance, Attorney Harry Roque is now adding to all the fears his fear that the killer of Jennifer Laude could also benefit from the rule. Private First Class Joseph Pemberton was found guilty of killing Laude in 2014 after finding out she was a transgender woman. They met at a disco bar in Olongapo, went to a nearby motel. Authorities say Pemberton left the motel after 30 minutes, during which he had most likely finished committing the crime. Roque says it is simply wrong to set aside the feelings of Laude's family if Pemberton were to walk away easily after the heinous crime.
Wag naman na parang hayop na papatayin ng isang Pilipina at ilang tulog lang ay pwede nang makalabas. Walang pagkakaiba yan dito kay Sanchez at Pemberton. Parehong kaduma-duma lang kanilang ginawa.